number 30, which is to receive interim report from the Travis County Ethics Policy Workgroup. Very excited to have you all here, and this is a wonderful, wonderful example of the tremendous civic engagement of folks who really could be doing something else, but instead, y'all were so enthusiastic at our request to be on this ethics committee, giving your time and your energy and your expertise for nothing except for the the applause of a grateful county. So, Mr. Sorrells, Mr. Gullahorn, Mr. Lewis. Of course, we had a whole bunch of county employees on this too, which also isn't directly in their job description, but they too were hugely enthusiastic about participating in this. So I really, really appreciate all your efforts in this, and stand ready to hear what our assignments are.
Good afternoon, Judge Eckhart and members of the court. What I'd like to do is just walk through the report that you have in front of you. We've also handed out to you a PowerPoint that sort of hits the main points of it. There's really 4 things we want to do. I want to just very quickly tell you the background and history of the working group. I want to lay out the recommendations and then talk about next steps and then have any questions and answer and discussion. The committee has unanimously stuck me with the job of doing most of the talking. However, I hope that they will join in any time that they have a particular comment to make, or if there's a conversation with the court at the end of the presentation. If you all have any questions, feel free to ask them, and we'll all try to chime in as best we can. The court created the Ethics Policy Working Group back on January 26 of 2016. There were 6 members to it, or 7 members to it, excuse me, I'm leaving myself out. And they're all here today, and I just want to recognize them. David Escamilla, Jack Gullahorn, Sid Grimes, Fred Lewis, Nikki Riley, and Tim Sorrells, and then myself as sort of a convener and wagon master or whatever, as we did it. I also do that. There were several times like that, Judge, yes. I also want to just recognize some people, particularly on county staff, who did a lot of work with us on this thing and provided a lot of invaluable suggestions and information and counsel. Elaine Casas and Bonnie Floyd from the purchasing office, John Hilley from the county attorney's office, Ron Morgan from the county clerk's office, and then Julie Wheeler and Caitlin Mark from our office. So we're very proud to have worked together on this. The guiding principles that we took from you all and tried to make the principles in trying to move forward with this were 3: openness, transparency, and accountability. And to make that even more open, transparent, and accountable to the people of Travis County. We held 9 meetings, including 2 conference calls, and came up with a passel of 11 recommendations. There was a lot of debate, disagreement, a lot of research done. We did not always agree about all the specifics of everything, but we did agree that we wanted to present to you a consensus report. There were several times during the process where one or the other of us would say, well, if you decide to go this way, I'll just do a minority report and I'll say I disagree with this particular recommendation. And every time the members of the group decide to pull together and try to work and refine a particular recommendation in order to make it so that everybody could feel comfortable going forward. Having said that, we also tried to do significant recommendations. We tried to give you something that was worth the work we'd put in and that was worthy of the trust you had given to the members of the committee in asking us to study these. We recognize, however, that it is going to be important going forward to have lots of conversations about this, to get input from affected stakeholders, our fellow county employees, and for the court to make some of the big choices that are at the end of the line on this. So with that in mind, I want to start talking about the recommendation. The first recommendation is that we ought to have some sort of document that reflects, that we can call a county code of conduct. Travis County, many of our business units have such documents. They have their own internal ethics policies. They have ethics policies policies with how they relate to the public that they deal with. The most obvious example being the purchasing code has extraordinary detailed provisions about the relationship between purchasing agents and county employees and the vendors that they work with. But our goal here, we think, and would recommend to the court, is to try to synthesize all that stuff and put it in one place so as to make it clear to all the members of the court and to all the employees of the county. That was one of the recommendations of the management report that you all received in July. And in that report, they suggested that the Human Resources Department ought to be sort of the lead agency as we go forward, trying to put together a code of conduct for the county. There are a number of examples that the court could turn to or that HR could turn to if you give them that task. We looked at stuff from NACO. We looked at stuff from several of the counties around the state, the other big counties, and then we also looked even at some counties around the nation. Recommendation number 2 is to examine the statutory and regulatory requirements regarding gifts. Gifts is a very complicated issue and a very fraught issue, but we wanted to look at what are the legal requirements regarding the acceptance of gifts and the solicitation of gifts by public employees, and are those reflected in Travis County policies, and to try to come up with a uniform and enforceable policy regarding gifts. Like I mentioned before, several of our business units here in the county do have their own internal policies about gifts, but there's not really much general policy about gifts, even just for the departments that report directly to the court. On the other hand, the guiding star for this is probably the Penal Code Chapter 36. But the Penal Code Chapter 36 is kind of complicated. It lays down a bunch of standards, but then it also talks about some exceptions. And depending upon the uniqueness of a situation, the exception may apply or may not apply. And frankly, even among us discussing this with as many smart people in the room as we had, we would get into a kind of interesting conversations about, well, does it forbid this? Does it prohibit that? So one of our concerns was to come down with a policy or to recommend a policy to the court that we thought could be uniformly understood, notwithstanding all the nuances of real life. And so we are going to recommend to the court that the county put a ban on any gifts that are received by or solicited by any county employee. That's a policy that the court's going to have to discuss and adopt. I think there's going to have to be some conversation about that, the practicalities of how would you actually implement that, how would you actually enforce that. But we recommend as a starting point that the court, that the county adopt a policy and the court adopt a policy for the county regarding banning the acceptance or solicitation of gifts. Again, in the context of purchasing, for instance, that's already pretty much the rule.
Now, is that everything from a meal to a Rolex watch?
That would be everything from a meal to a Rolex watch.
From a bottle of water.
Well, that's what the committee is recommending, that we ban that?
No.
Okay, well, let me get that straight then, Amina.
The language is more clear in the recommendation. It's really as a starting point to say this is, a goal, but that we recognize there are practicalities and that you will have to consider in developing it. That was my understanding.
Yeah, and I think the challenge is I think the thing we're concerned about is that the court try to come up with something that's pretty understandable by county employees and that they understand what you are expecting of them. And as David mentioned, there's complexities to that, and it may be difficult for the court to fashion exactly what that is. But we think a good starting point is just to say, let's look at banning gifts totally, and then let's look at what the practical application of that might look like.
So when do we want to take that on? Right now or at the end? I mean, because I don't...
Well, I'll tell you, this is a very big, this is an issue that I think needs to be discussed, and I think it needs, if the Ethics Committee is willing to continue on, I think it would be beneficial to bring other people into the conversation as a committee and discuss some specifics. So that we can really narrow down a bright line rule. I am in agreement with the recommendation that the rule must be bright line. And in the absence of being able to locate that bright line, total abstinence may be the only bright line we could achieve.
And I agree with that recommendation as well.
And I know that that's difficult. It does go all the way down to a bottle of water. But we have had gray areas we've had gray areas that frankly are anxiety provoking. We've had gray areas that make the county vulnerable to a perception of unethical behavior, and we're frankly pretty close to the bone. I mean, we're not wacky, crazy. We're not having lavish parties over there in the multifunction room. I buy sodas with my campaign money so that I can provide sodas to guests who come, because we have actually a budget rule that says I can't buy them with my county budget. So that's a wonderful thing. We're even arguably penurious. When Judge Biscoe retired, there was an attempt to buy him a gift, but we determined that we really couldn't buy him a gift, that we couldn't figure out a way that would be appropriate under the rules to buy him a gift. So we do need to, I think, have an internal conversation about how this rule should be written, so that we don't hamper ourselves with unnecessary anxiety, but we also don't kick open the barn doors to perhaps some corporate cultural behavior that we wouldn't be proud of.
So, could I just ask a question, Judge? This merits more conversation from us, Commissioner Daugherty, because it's an incredibly broad recommendation. But I didn't know if we wanted to go through all of these first and come back to this, or how y'all wanted to do it, because
I think that we should probably go through all the recommendations first, and then as time permitting, we can come back and at least have an initial conversation about the gifts policy. Because I can also see, as many taxing entities have done, when a property is worth below X, they don't even appraise it anymore, because the headache of appraising it and trying to collect taxes on it is worth more than the actual effort. So it could be that we get to a point where if it's something that's worth $5 or less, don't worry about it. So if somebody offers you a bottle of water that's worth less than $5, just walk on down the road, say thank you very much, and sip away. But let's go through the rest of the recommendations and come back to this one. Is that good? Okay.
The next two recommendations have to do with the implementation of House Bill 1295, which was passed last session. The purpose of House Bill 1295 was to put more transparency into the contracting process, so that if there were parties who had been attempting to influence contracting decisions, whether we're talking about purchasing decisions or other kinds of contracting decisions, that there would be a way for the vendors or the parties involved in those contracts to go ahead and identify which parties had assisted them in doing that. We're talking about people like brokers or attorneys or lobbyists, that sort of thing. Right after House Bill 1295 passed, Purchasing put together a set of rules for implementing House Bill 1295 and actually had those up and running by the time the bill took effect. But in the course of our deliberations, one of the things we identified was that there are some county contracts that are subject to House Bill 1295, but that are not necessarily run through the purchasing process as we understand it. So our first recommendation, recommendation 3, is to make sure that we're going back and looking at all the contracts as defined in the statute, and that that we're complying with the House Bill 1295 requirements for those contracts. And there might be some areas like contracts for land purchases, which may not go through the purchasing process, but which still are subject to House Bill 1295. And the idea would be for the county attorney just to keep an eye on that and to advise the court when a particular contract or a particular decision of the court is affected by House Bill 1295. So that's recommendation 3. Recommendation number 4 was that since House Bill 1295 was really all about transparency, as part of that bill, there is a part of the Ethics Commission website where reports on these contracts and who were advisors and who were brokers on particular purchasing decisions, there's a place where that has to be reported to the Ethics Commission. The Ethics Commission now maintains a database of that. So recommendation number 4 simply says, let's have a link on our Travis County website so that people that are interested in this can go look at the Ethics Commission website and go straight to the website and do their own research about purchasing contracts, or again, I don't want to limit it to purchasing, but contracts made with Travis County. That's recommendation number 4. Recommendation number 5 has to do with the larger issue of identifying vendors who are trying to do business with the county through the purchasing and contracting process. It is one of the most important ways in which you make decisions about how to spend the county's money. You have money invested in personnel, you have money invested in physical plant, but a lot of the decisions you all make have to do with contracts that you issue, long range, I'm thinking of like computer systems and that sort of thing. And in order to get more information up front about who are participating in those and what are the vendors and what are their relationships with the county, we're going to recommend the creation of a pre-solicitation ethics affidavit, which would supplement the current ethics affidavit that vendors already have to complete, and would ask them for information about 2 things. What were the political contributions that they made within the last year to people who might be affected by the contract they're bidding on? As you know, the purchasing office maintains a list of what's called the key contracting persons. Those are updated on every contract to be specific to that contract. And the goal of this would be that a vendor would have to report any of the people on that key contracting list. Could include members of the court, could include an independent elected official who the contract would affect, for instance, say the sheriff's office or the constables, and then also to report any lobbying expenses that they had incurred in trying to solicit or gain that contract. So 2 issues here. One is political contributions made to key contracting persons that are affected by the contract, and secondly, lobbying expenses involved with the contract. So what we're recommending is that we think this would promote transparency and accountability. It would make basic information available without complicating the process. There's a somewhat lengthy discussion in the actual report about how to do this in such a way that would not create really a burden on the vendors themselves in trying to comply with this, but would allow the county to have information available on its website about these transactions and who would receive contributions, whether or not lobbyists had been hired, how much they'd been retained for. Recommendation number 6. Right now we have, as you know, all candidates and elected officials are required to provide campaign finance reports. However, there's a standard for campaign finance report that applies to state officials. However, that same standard does not apply to county officials in terms of the process you use in order to do it. What we're going to recommend is that the campaign finance reports be filed electronically. That is a easier way to do it, and what it does is allow us to create a searchable database, again, on the county website. As you know, the county clerk has all the campaign finance reports on her website, but in order to find out, for instance, did D. Sextine give contributions to any county elected officials in the last year, you literally have to go through the reports one by one. I think once you have a particular report open, you might be able to search it, but there's no kind of way to centralize that and make it more user-friendly for the public to be able to see. So we have been working with the county clerk, Ron Morgan, who I mentioned earlier and gave some props to, work with us on trying to think through the mechanics of how to design a system that will allow us to do this, and we think we can have it in place probably in time for the 2018 year. I know he hates me trying to commit him to that, but that at least is the recommendation of the group.
Can I just ask quickly, this follows the county follows the state ethics reporting requirements, correct? Essentially,
yes. Except for the form of the actual report.
But the state reporting is online. is it?
Well,
not?
the state reporting is online. However, somebody else probably knows this better than I do.
Well, the issue is that the state level, they're required to report electronically. They're not required to report electronically at the county level, and the county really can't pass an ordinance, for want of a better word, or a code provision that says you have to do it. And there's some things at the state level, like employer occupation information, it's not required at the county level. So I think the idea is to kind of get everything in line where it'll make the reports more accessible to the public, more transparent. So when somebody wants to go in there and look and see what's going on, they'll be able to do that.
We could pass an ordinance requiring ourselves to report online, couldn't we?
But couldn't this be
think
on
so.
our legislative list?
Yeah, it'd be a legislative action.
Yeah.
It would be a legislative action to be, it would be a lot easier if we were able to report it electronically. But I don't know if you all, I know that I'm pretty sure at least Commissioner Gomez and I were both caught up in this. But a few years back, you may have been off the Commissioner's Court during this time, there was a group out of the Woodlands that came after all of us on ethics complaints. And one of the complaints was that, at least in the complaint against me, was that I had duplicated the state promulgated form so that I could use Quicken to self-load all of my campaign contributions and file it. And they said that that was actually a violation of state law because it wasn't the state promulgated form. I had basically duplicated it in a Word document and pre-filled it from Quicken. And actually, the Ethics Commission upheld that as a violation. So I think actually many folks locally would much prefer to file electronically. We're just not able to.
Yeah, well, I mean, you can use the state software right now to print it out or to fill it out, but you can't file it electronically. I mean, you can put it on a disk, I guess, and send it over, and the county could download the disk. But it's not the same as the electronic filing system in the state. And you're right. The statute does require that it be in a form prescribed by the commission. And, when I was over there, we get all kind of weird forms, many of which didn't have a lot of the information on it. It was hard to find, so they kind of did have a bright line rule about.
But we get those forms, though. The forms that we get to fill out are the ones that we download from the Ethics Commission.
Correct.
And I think with mine, it was that I didn't fill in all of the blanks the way they're laid out. But if you look at some of the reports now, a lot of folks are not filling out those boxes either. So there's got to be a lot of training for candidates to make sure they fill out every block. So
I would say we got substantive complaints and it's kind of non-substantive complaints.
Those are pretty non-substantive complaints. But at some point, and this goes perhaps beyond the work of this group, but the state promulgated form in itself, the front page, doesn't balance. So it's not particularly helpful. It doesn't balance to the previous form filed 6 months prior, and so it's in itself is kind of a strange document.
It is. I mean, and that's part of what they've done over the years of promulgating these new forms. But it's really the way the statute's written. It can't balance under the. If you follow the reporting requirements of state law, oftentimes it's not going to balance.
Okay.
And so they have now promulgated all these new forms to use, so you can have a form that shows expenses that you've incurred and hadn't paid and that sort of thing to try to get to that. But the bottom line is, I think, on the electronic filing is to just make it transparent, to use what the state has, at least their guidelines, in a way that somebody could go on the county website and look it up and kind of see what's going on.
And I think that would be very helpful. I mean, basically what we're after is if somebody is concerned that someone has undue leverage against a particular local official, they can go and search for Mr. X and see how much money is Mr. X given to all of the local elected officials.
Yep.
I did want to point out that a number of the large cities in the state, because they have plenary home rule authority, are now requiring mandatory electronic filing. The city of Austin's done it, I guess, for about a year and a half now. And basically what we tried to do is using different things to get us as close to electronic filing without having to have manual entry as possible. But it'd be a lot easier with statutory authority.
But just so I'm clear, is recommendation 6A like to have rather than a have to have?
No, what recommendation 6 says is the county, as I understand it, the county will offer electronic filing to people. If they take it voluntarily, you have the data in electronic form. Second, the county will encourage people to file the PDFs in typed form because you can take that and put it into a searchable database. And then those for people who want to write it by hand for whatever reason, they can't type or they want to make it difficult, the county will have to manually enter it. That's why it would be a lot better than having that Rube Goldberg three-piece system to just have mandatory filing with an exemption like the state has for people whose campaigns are under $20,000 or something. But as you know, most everybody keeps their contributions on their computer anyway. Like you were talking about, an Excel spreadsheet is frankly just easier to download it into the database.
Much easier.
With the idea that the second part of this would be to create a database available on the county website where you could do searches and download information if you wanted to.
So there's no problem with state law if we create a database at the county and we encourage people to upload their campaign finance reports to that database. We aren't in violation of state law if we do that, are we?
No.
Okay, I was just trying to clarify what we could do.
I think the tricky part of this is, as Fred said, there are a variety of ways in which you can file your information now, and electronic filing, which is the way the state does it, is mandatory for the state, but it's not mandatory for us. And so
voluntary.
It's voluntary for us, and we'd like to move it towards being this is the uniform way in which people are going to report here at the county level. And we may need legislative authority to make it mandatory, and we'll talk about that with recommendation number 11. But we're also looking at how to create a system that has the right incentives in it and makes it easy for people to operate in that way.
Yeah. Thank you.
Recommendation number 7 has to do with the uniform appointments process. As you know, the court has worked for the last several years to move some of the many boards and commissions to which the court makes appointments into what we call the uniform appointment process. And in our conversations with the court, an ongoing concern has been to look at conflicts of interest and to make sure that as a court we're on top of those before and during a person's service on a board or commission. And then secondly, to look at the court's authority to be able to remove people for good cause in the court's opinion. But before that, I want to mention that although we had some conversation back and forth about it on the committee, we were in agreement also that as a principle of this, that we ought to try to have a set of appointees who reflect the diversity of the county. We have so much diversity, geographical, age, ethnic, and so forth, and we want to reflect as much as possible that diversity. So one of the goals we want to set forth in our recommendations is that the court's appointments, at least to the UAP boards and commissions, ought to try to reflect some of that diversity. So the second recommendation we make, we've already taken some steps on conflicts of interest. As you know, right now it's already the court's policy that unless there is already a conflict of interest requirement or a particular form that a board or commission requires, we ask everybody to complete what we call the Chapter 171 affidavit. Chapter 171 is a portion of the government code that has to do with conflicts of interest. So we ask all our applicants to complete that. We might ask the court to consider requiring those people or asking those people somehow to update the information as they go on. With respect to the area of removals, the court now has authority to remove members of 7 of the 13 UAP boards and commissions. So we ought to look at whether or not, and if so, how the court could retain the ability to be able to remove a member for good cause. And there's a variety of issues to that. We had presented to the court, I think back in June or July, some information about which boards and commissions would allow removals. So that's, I think the work group felt that that was another issue that deserved further study by the court. Recommendation number 8 is to put, right now, if you want to know how Judge Eckhart voted, say, over the last 3 months on issues having to do with contracts, with purchasing decisions, you would have to go back through every agenda for those 3 months. You would have to find what the items were that had to do with purchasing decisions, and then you'd have to call up the minutes for that to find out what Judge Eckhart's vote was. So it's a very laborious system for people, for citizens to be able to find out what decisions their elected officials have been making. In the interest of greater transparency, greater accountability, we recommend developing a database where you would pull that information out of the minutes, pull that information out of the court's documents, and put it into a searchable database so that you could, so that a citizen could find out what the votes were of a particular elected official on the court over a period of time or on certain subject matters and so forth. This is another recommendation where we've been very grateful for the help and assistance that the county clerk, Dana DeBevoise, and her assistant, Ron, have offered to us. They have been thinking with us about how to do that. The court has a system, I believe it's pronounced Acela or Excella, that does all its documentation, and we would like to work with the county clerk if you give us the go-ahead, or we'd like the court to work with the county clerk in order to develop a system that would allow that information. I keep giving myself more work in the future. I should be careful. Recommendation number 9. Again, given the scope of some of the recommendations that we're making, given just the intricacy of some of them, and given the fact that we're really trying to address some good, positive changes in culture, we want to recommend that the court move slowly with the implementation of these recommendations. Make sure that there's a lot of public education, both with internally here with county employees and with the public at large, that we take the time it takes to work through all the practical problems of trying to adopt some of these policies, and that we give ourselves time in order to do that. We think that that's going to be the better course for the court. I think the court has tentatively scheduled a work session on October 27th. We would like to recommend that as a starting point, just to get input from county employees and other stakeholders in general about these recommendations. And then to allow the court going forward, to decide how it wants to, which ones it wants to move forward on and how it wants to task that out to people. Recommendation number 10 is that the court should review the changes annually. This is a very fluid area, and there are a lot of things moving on around us in terms of people's relationships with their government, people's expectations of the county and of their elected officials. So we want to make sure that our policies are always reviewed and under scrutiny. Frankly, after all the work we did, I don't know if annually is the right sequence. Maybe it might be every 2 years or something. But we think that would be a good idea. Recommendation number 11 is our last recommendation, and that is to consider additions to the legislative agenda for the 85th legislature to clarify the county's authorities in some of these areas. And there are 3 specific recommendations that the committee discussed. First, the mandatory electronic filing, to clarify statutory authority to do that to the extent we need that. Secondly, to allow a county to adopt a lobby registration and reporting rules scheme similar to what the state has in Chapter 305 of the Government Code, and to allow counties to adopt that. Let me say that about both of those, I think the sense of the committee was our focus is on Travis County. If this ends up being a bracketed bill that applies only to Travis County, fine. We're certainly, if the court asks us to go forward with this, going to be talking to our colleagues in other counties and seeing whether or not they want to work with us on this or whether we can go it alone. The final recommendation is to support a legislative override of the Boeing Company versus Paxton decision, which was a decision having to do with the Open Records Act and whether or not a vendor who is doing business with the county can assert a confidentiality privilege in vis-a-vis an open records request. So those are the recommendations. I guess I want to finish off by saying just two comments. First of all, we're real proud that the court got into this proactively. There was not some bad stories in the newspaper. Nobody has gotten indicted that I know of. I checked my mail this morning.
David
you know,
would know. Have any of us been indicted?
David can't comment on that. The day's not over yet.
I'll place agenda item 30 for executive session discussion.
But you know, we have good people in the county, and most of the people in our county want to do the right thing, want to serve the people of their community, want to do a good job for them. Certainly, that is the example that the court sets for everybody in its own, in your own work ethic and in your own values that you have expressed from the bench. So we're proud that the court is acting proactively on this and trying really to take us to another level as a county. And we're glad to have been part of that. And I'm personally proud to have had the chance just to work with these people. I will tell you that the meetings we had were actually the most fun thing I was probably doing this year, just because there was a lot of brain power in the room, and there was nobody who was shy about expressing his or her opinion. So we always had very good, rich meetings, and I'm just glad that the court let me be part of it. We're happy to answer any questions, or if any of the members of the work group want to make any comments, that might be appropriate now.
If it's okay, I thought we were going to meet at 1:45, and so I have a 3:30 appointment. If I could just make a couple of points, and then I'll go, if that's okay.
Well, sure, because we're going to have another opportunity in work session on October 27th to do a deeper dive on these recommendations. So. Okay.
Do you want me to go ahead, or
yes,
wait?
Please.
Okay. I wanted to thank you for allowing me to serve. It was an honor. We actually have an excellent report. It is a difficult subject area with the county because of your limited authority. It's a lot easier to work on it on the city, which Mr. Gullahorn and I have also done. I wanted to say that transparency is crucial for the functioning of government and for people's faith in government, and that's what this is mostly about. And the other thing is it's always better to be proactive. El Paso has authority to do a lot of ethics and campaign finance, but it came after indictments and problems, and it's always better to get ahead of things. I wanted to make a couple of points about, first, Recommendation 11, about the statutory authority. Your authority is basically limited to protecting the integrity of the contracting process, but there are other decisions you make that the public would like to have transparency on, subdivision agreements, other things besides contracting. And so I would really recommend that you be proactive. Frankly, what other counties wish to do doesn't really matter much to me. So I hope that at least they would allow Travis County to be able to pass the type of transparency laws that it wants to have. Second of all, I wanted to talk about Recommendation 2 in the gift ban. I worked at the Attorney General's office for 5 or 6 years, and we had a gift ban. And it was the best way to do it. A lot of people don't understand the penal provisions. If you read 36.02 and some of the other provisions, at least as a lawyer, you'll never take a gift anyway. So the best thing is, I've noticed, I can't talk about the county, but the city, there is such confusion. What's a gift? When can I take a gift? The lawyers don't agree. So to me, the better practice is just no. I can tell you it wasn't difficult to comply with as an assistant attorney general. I didn't have a problem. I took the water when they offered it to me. I didn't take the lunches. But I think it's best to have a clear policy that people can understand, and no is a clear policy. And I know it can work because I was under it for 5 years and I never had a problem. Although I did drink the water and no one ever really complained, or at least not to me. The last thing I wanted to say is about the conflicts of interest. I signed onto the report, but I do think the better policy would be to apply the conflicts of interest policy to all your boards and to all of the elected county officials. Why do I say that? Because as a lawyer, I can tell you the one thing you can never explain to people is why you acted when you had a conflict of interest. The other thing I've noticed over the years is no one sees their own conflict of interest. And so the best policy is to be proactive so that you're not up there having to explain why some appointee of yours on some board couldn't understand that conflicts of interest rules applied to them and they should be circumspect when we didn't make it apply but to 13 boards and they weren't on that board. So I think the better policy is to be proactive. But I do think starting with 13 boards is a good step. And with that, I'll stop. Thank you for allowing me to serve. I think we've got a lot of good recommendations that bring the county into the 21st century and allow the citizens to know better what their government's doing. And that's always a good thing.
Thank you, Mr. Lewis.
Thank you, Fred.
Now, I know that Jack and Tim can't let it lie there.
Well, we are lawyers.
Well, I was going to say, 5 lawyers, 1 auditor, and 1 purchasing agent walk into a room. This is not the beginning of
There's
a
a joke
joke.
there somewhere.
Walk into a bar.
Yes.
Thanks, Fred.
Commissioner Daugherty, I wanted to come back to recommendation 2 because, frankly, that was the toughest of all of these, I think, from our standpoint on trying to figure out where we wanted to head. As a preface to all of that, I want to echo what Fred has said, but also to you and Julie and the county employees that worked on this. This was, I shouldn't say that I was surprised, but I was really impressed with both the knowledge, but more than anything, the willingness of people to engage in meaningful dialogue with us on some of these technical points that, frankly, don't make any common sense when we're trying to address them. And we worked through a lot of issues that I think are going to ultimately turn out to give this county an opportunity to adopt probably the most comprehensive and fair ethics ordinance, should you choose to go in this direction, that any county will have. So that's one of the things I think that drove so much of this. The gifts and benefits section, the recommendation of the committee, Commissioner, is that there is a bright line, and that bright line should be that if you're a county official or a county employee, you shouldn't take a gift, nor should one be given to you by anybody. The question then becomes, what's a gift? Well, in the context of what is a gift, it's any benefit. The penal code defines a benefit as of anything of pecuniary value, so that's how you get down to a bottle of water. Our recommendation is that as a starting point, let's put it this way. The recommendation says as a starting point, our recommendation is that the bright line ought to be, you just don't take any gifts. No county employee, no anyone can do it. Now, there's a limited amount of authority, I believe, for the court to tell some different departments what they can and can't do, and I think every department or other part of the county would have the opportunity to look at it on their own. And I would hasten to add that David has certainly been our conscience on this as far as practicality. I don't want to. I don't want to say anything that sounds like he was not strong for what we were trying to do. But I think there's a lot of practical aspects to a total gift ban that David continues to bring to us, and that's the reason that we've recommended this as a starting point. We think it's a good starting point. We think that's where hopefully you'll end up, is something close to this. But to give you a couple of examples, what do you do with a working lunch when you go to work when you or an employee goes somewhere? Well, there are a lot of different answers, and we're hoping that the county will look at some of the opportunities for this. What do you do when someone invites you to sit at a table for a charity function? That's a benefit. It's a benefit of food and beverage. What do you do when unsolicited someone sends in a barrel of pick something, out of the blue, chocolate-covered popcorn or something like that to an office? What do they do with it? It's a gift. They shouldn't accept it. All of these are devil in the details that we have to look at. But fundamentally, I believe, and I think that that, as a general statement, that this committee believes that the bright line should be, if you're a county employee, the citizens of this county don't expect you to be taking gifts from anybody. What's there. And so then it becomes a question of, okay, do we have something that's enforceable? Do we have something that's practical, but that captures that sentiment? I personally believe that one of the provisions in the penal code pretty much restricts the ability of anybody to take any gift anyway. But that's debatable. There are two different provisions in the penal code, plus the honorarium provision, which I think all of you are familiar with, that are basically say you can't take gifts, and in one instance there are exceptions. From our standpoint, most of those exceptions shouldn't apply. Should someone take tickets to ACL? Well, that's pretty much going towards your Rolex watch, Commissioner. Should someone, but if really they're charged with or F1 or something like that, they're charged with monitoring some kind of county role, would it be educational for them to do it? If it is, then the county ought to pay for it. Or if it's an office holder, the office holder has the opportunity out of their office holder funds, which in many instances are limited, to do it. But that's what we hope that you will look at. We hope that you'll look at this as a baseline, and the baseline ought to be, no, we can't take it. We don't need to take it. We shouldn't encourage anything to anyone to take something, because that then creates something that drives us away from a bright line. Okay, you can take food and beverage up to $50 to $25. Is that a day? Is that a meal? What is it? What if they split the ticket? What if it's... There's all kinds of things that you get into that, frankly, we don't think it's worth it. And from a strong ethics policy for the county, we encourage you to look at this as an absolute, and then let's look at the practical problems, because I think there's ways to deal with some of this, frankly, that don't really violate the sentiment of what we're trying to do. So again, I appreciate the opportunity to have worked on this. The other thing I would add is if in one other thing that's here is we are recommending a lobbyist registration policy for procurement. And I don't know, Deese, if that came through, because I didn't see anybody wince, and I kind of figured that at some point we would do that. But that's what we believe the county has the authority to do. And my objective in the discussions has been to keep that as minimally intrusive as possible, but to give the public an opportunity to know who's getting compensated to try to influence decisions dealing with procurement and how far that ought to go. So to me, those are kind of the big ticket items that are in this recommendation in terms of probably maybe I won't say dissension, but conversation and a lot of objection maybe from different types of people. But I believe that in both of these instances they're warranted. I think it increases transparency. I think it gives the opportunity for us to have a stronger ordinance overall, and that's what I hope that you will consider doing. So appreciate it. And frankly, Commissioner Daugherty, I appreciate your response to that initially, because it's a terribly difficult thing to look at in trying to figure out how you enforce and really what makes sense. But I think that we can get there.
Well, the reason I have a problem with it is so often we really do need to do things after hours. I mean, because it is a gathering of information. And if anybody thinks that I'm going to do something for somebody because they bought me a $52 steak, well, then they don't know me very well. So it's a personal. I mean, it's a
wow, $52 steak. Hold up.
It's an insult to me. I mean, and that's the reason I have I mean, you know, I had an $11.82 breakfast this morning that I said, no, I mean, hey, let me pick it up. I mean, because sometimes, you know, I will pick it up for someone. So it just, I mean, you know, you can make a point with it, and I understand the point. And it's probably better just to kind of go, don't do any of it.
Yeah.
But you know, I tell you what, if any of us can be bought over an $11.82 breakfast or a $52 dinner, then maybe somebody ought to prosecute us, and maybe we ought to go on about our business. But if we've gotten to the point in this country where that's what we've got, because there is a lot asked of us as elected officials, and so that's the reason I'm not comfortable with it. I mean, you know, I'm just one of 5 on the court, and you know, 4 people say this is what the policy is going to be. Okay, I mean, you live with the policy. Doesn't make me any happier, but I can afford my $52 steak. Sure I can. And I think probably most of us can. So it's just a personal deal. I mean, it kind of pokes me in the eye, and I'm like, I don't like that.
And I'm sorry, and Commissioner, if I could just respond kind of personally to you. I know you can't be bought for $11.82. I'm pretty sure that anybody you would ever have lunch or dinner or tacos with would know you can't be bought for $11.82. But there's a deep cynicism that people have that I see over at the Capitol all the time when people are being bought $52 steaks all the time. That was a sidebar comment. But, I mean, Commissioner, there are people who are deeply suspicious of government, and they really do think that, y'all are on the take, and I'm on the take, and everybody's on the take, and the absurdity of that does not go away just because it's absurd. And so I really respect and recognize kind of your frustration with feeling like this is all penny ante. But I just would invite you and the other members of the court to realize that we're also talking to a larger community out there, that sometimes people are inclined to believe bad messages, and there are certainly people out there willing to give those bad messages.
There's also an unintended benefit. I can say anecdotally that one entity that for reasons I frankly don't know, felt obligated to provide literally stacks of tickets for county employee use. When I told them you no longer have to do that, they were so relieved. They were relieved.
I wanted to add something too, if I may, and kind of echo what Jack and Fred said, and Dee to some extent. And first, I want to thank you as well for letting me serve on this work group, and for all the people I work with. It's been great working with them.
Thanks for
and to kind of get back on the gift thing again, I totally understand where you're coming from, Commissioner Doherty, and I've heard that for years, working over at the Ethics Commission, and before that I worked as an assistant district attorney. I worked for elected officials at the state level before there was an Ethics Commission, when Claire Dawson Brown came over and gave us our ethics training about gifts and what we could and could not take. Every single one of those agencies I worked for had a gift ban in it, and we just didn't take anything. And I think the idea was behind it was kind of what Dees was saying. It's not that somebody could be bought. It's just that your everyday man on the street, woman on the street, person in the community, they don't get people buying them $52 steaks. And they don't get breakfast tacos brought to their office every morning. They don't get coffee brought to their office every morning. And it's just these little gifts, these little benefits that kind of that add up over time, I think people think. And then they think, well, I can't afford to buy them breakfast tacos every day or coffee every morning. When I go into that office, am I getting treated the same way as everybody else that walks in there? And I think that's kind of the issue, and I think that's why we started from the bright line rule on the gift ban. And as Jack has explained, there may be some tweaking that needs to be done or could be done in places. But if there is, it should not subsume the intent of that rule. So I would encourage the Commissioners Court to be careful in tweaking with it too much, because I think it is a public confidence issue, and I think that's important.
We'll definitely have more conversation about this. Commissioner Shea?
I did have a question about the, I don't know if it's recommendation number 5 or number 3, but the definition of vendors or people seeking contracts from the county. One of the things that is a new category for us is PIDs.
Is what?
PIDs, Public Improvement Districts. And in many cases, the ask is quite large. $65 million, I think, is the largest one we've seen so far. And I think that should be included in it as well, but I don't think they would fit the typical definition of a vendor or someone seeking a contract. And I don't know how we would manage that.
I think that's good to come from the details, Commissioner. The work we need to do, an intent by the Commissioners Court to look into that, could certainly be done. The other thing to consider, though, is PIDs also have statutory regulation, and so the question would also be, can we add, and to what extent can we add additional requirements to a PID application? But yeah, certainly, we'll have to, as we move down, there will be many legal issues come through you have to be advised about and make tough choices.
So, but that's the kind of thing where I'd like us to be mindful of other areas where people are seeking something of real value from the county. And, how can we, again, establish this bright line? Because there is so much cynicism out there. I mean, to me, it's incredibly corrosive to the entire democratic process. And it's hard to explain to people that the political process has integrity when people can see so many examples of things that look fishy to them. And I think that's a lot of what we're dealing with here is stuff that doesn't look right. I mean, the sense people have that the political process is rigged, to me, is overwhelming. I don't think I've ever seen a time when there's such a profound sense that the political process is stacked against the ordinary person. And so I think we have an additional duty to do what we can to try and right that ship.
To go the extra mile to make
Exactly,
sure that
to go
they
the extra
know
mile. Exactly.
that we're doing well.
I'd rather tell that in executive session to explain that answer.
Okay.
Yeah, so we don't have to answer it right now, but I'm just saying
Executive session, but
I'm just saying as a general goal that
There are
I would like
reasons.
to see where we can apply this as broadly as possible.
Right.
Yeah.
So what we will do in work session on the 27th is we will also reserve the possibility of going into executive session for some of the more legally nuanced issues and how to apply these recommendations. So we will have that more robust conversation on the 27th, and I would encourage the members of the Commissioners Court to reach out to Deese in advance of that executive session and provide him your questions and areas of concern that you really want to explore so that we can maximize that time, because I think it's going to be a really, really fruitful conversation.
And Judge, I would just like to say for the record, I would like for us to seek to apply some of these reporting requirements and conflict requirements and disclosure requirements as broadly as possible to our appointees. If we're only able to apply it now to 13, I'd love for us to see how we can broaden that as much as possible.
Thanks for this tremendous work. We
Yeah, thank you all.
so
Really
appreciate
your
it.
service.
Thank you.
To find out who Jack and Fred were. I already knew Tim, but it was a good group.
Yeah, thank you
It's a very
so
good
much.
group.
I really
Thanks to
appreciate
all
your
of
time.
you.
I'm
I'm proud to say that about a
envious
bunch
that
of lawyers.
Yeah, I'm envious of y'all's work. I would have liked to have been in those meetings with you. The brain trust was, I'm from the shallow end of that gene pool, so.
I don't think so.
I wouldn't have been able to swim in those deep waters with y'all.
Thanks very much.